Dorothy is reported on her way, so we'll start. Speak of the angels and you hear the flutter of their wings. Good morning and welcome to the 17th lecture in the Examining Division's continuing series, The View from the Other Side. Our guest this morning is Peter Jaszi, Professor of Law, Washington College of Law at the American University. Professor Jaszi graduated magna cum laude from Harvard College and received his JD degree from Harvard Law School. He is one of the preeminent movers and shakers in copyright, and his interest in works protected by copyright goes back to his undergraduate days at Harvard. He served on the editorial board of the Crimson and on the executive committee of the Drama Club. At Harvard Law School, working as a teaching fellow, he conducted seminars in motion picture history and motion picture criticism. He also ran a commercial motion picture theater, all while carrying a full academic workload at law school. It was all I could do to keep up with my academics at Georgetown. I suppose there are two explanations. Either Harvard is much easier than Georgetown, or that Peter is much smarter than I am. After law school, Peter's career took a different direction. He went to work for a DC law firm and worked on criminal cases. He studied local jails. He wrote a book on his experience called Jails. He also served on two task forces, the Task Force on Disorders and Terrorism and the Task Force on Community Crime Prevention, all of which prepared him for his entry into the copyright world. Within the copyright community, Professor Jaszi is widely respected as a speaker, litigator, and author. Just last month, he joined us for a copyright law conference here in the Mumford Room and gave us a great lecture on copyrightability. I hope he will treat all of you today to a glimpse of his Billy the Bunny theory. As a litigator, Mr. Jaszi was co-counsel for the successful appellant in a motion picture copyright case that many of you are probably familiar with, Rohauer versus Killiam Shows, Inc. Mr. Jaszi is a widely published author, both in the criminal justice field and in copyright, and he calls his latest work in progress The Problem of Substantial Similarity in Copyright Litigation Involving Audiovisual Works. I want to talk to you about the title. Oh. The topic Professor Jaszi has chosen today is one that has its roots in the idea-expression dichotomy of copyright, and one that has recently been raised in the courts. The language look and feel traces its origins to a Ninth Circuit case, Roth greeting cards in 1970, and the McDonald-Lands case in 1977. As you know, we have several look and feel cases pending, and we've scheduled a hearing for September 9th. I suspect that Dorothy will probably see your lecture as one long ex parte communication. Close your ears, Dorothy. Without further ado, let me introduce, ladies and gentlemen, Professor Peter Jaszi.
I'm not technologically. No, far from us. Let's see. It doesn't go on top of. Thank you. Perfect. Let's do some here. On the thickness. Excellent. I think that'll hold fine. Well, I should start by recommending to any of you who may be considering attending law school, running a movie theater at the same time. I'm convinced that I never would have made it through law school had I not had something else to occupy my attention for most of my waking hours. And in the end, I came out knowing not very much about law, but a lot about movies, and I suspect that that's why I drifted eventually into copyright. Billy the Bunny couldn't make it this morning. He sends his apologies. I couldn't figure out a way to shoehorn him into this lecture, so we'll have to wait till next time for Billy. I couldn't figure out any way to connect up Billy the Bunny and what I want to talk about this morning, which is an anniversary of sorts, to which Ralph has already alluded. This is the anniversary season for the field of copyright. Our happy anniversaries are before us, the anniversary of the constitutional clause in the first act. But this morning I want to talk about an anniversary which I think is less auspicious, at least from my point of view, and that is the 10th anniversary of the decision in Sid and Marty Krofft against McDonald's Incorporated. What I want to argue this morning is that largely without having been noticed, a transformation has been taking place over the last 10 years in the American law of copyright. That as you in this office have labored to define and refine standards of copyrightability, and as the members of the legislature have worked on those same important tasks, the judicial branch has been quietly, de facto, reformulating the standards by which the assessment of substantial similarity in infringement actions is judged, and in doing so has effectively brought about a dramatic expansion in the scope of copyright protection. As you here and as the representatives in Congress worry about fine-tuning the scope of copyright at the copyrightability end of the scale, the courts have been making drastic revisions and adjustments by changing and altering their approach to the decision of infringement actions. I'm going to suggest that this trend is not necessarily a desirable one. I'm going to have the temerity to disagree with that famous comment attributed to Mae West that too much of a good thing is wonderful. I'm going to suggest that at least where copyright is concerned, that may not be the case. And while I'm throwing stones at cultural icons, let me lob one in the direction of a figure almost as well respected in the copyright community as Mae West, that is Judge Learned Hand. Copyright teachers are supposed to have nothing but good to say about Learned Hand, and I certainly yield to no one in my respect for the many contributions that the great judge made to the progress of the field. But I think that in a few, perhaps more than a few instances, Judge Hand or Judge Hand's followers may have contributed, perhaps inadvertently, to retarding the growth of the field. And one particular that I'd like to refer to is a line, a much-quoted line, in Judge Hand's justly a famous opinion in the Peter Pan Fabrics against Martin Wiener case. That's the line where he refers to infringement decision-making as, quote, inevitably ad hoc. Well, there's a lot of truth in that. And I suppose there's never any harm in having an obvious truth clearly recognized. The difficulty is that when an obvious truth is recognized by a figure as distinguished as Judge Hand, there can be unexpected consequences. And in this case, I think, one of the unexpected consequences of Judge Hand's characterization of infringement decision-making is that it has discouraged intellectual inquiry with respect to the field of infringement. Courts have taken Hand's characterization of infringement decision-making as a kind of license to improvise, and academics have taken it as an excuse to avoid thinking, writing, or teaching about infringement-related issues, preferring to focus their attention on other, perhaps equally important, and certainly more manageable, more easily defined, more easily grasped, less protean, less messy sorts of issues. Certainly, infringement decision-making is highly situational. But I think that there are good reasons to think that despite that, there is a lot that can and should be discussed with respect to it. And that's what I'm going to try to do this morning for a little while as I outline to you my concerns about Croft and its progeny. If I had more time and a less knowledgeable audience, I'd probably approach this all historically. I'd probably start, as I'm starting in this article in progress to which Ralph referred, back someplace in the 18th century and work forward. Develop for you the different schools, the different approaches to thinking about tests for infringement that have been current from time to time in the English and in the American cases. It is indeed a fascinating, fascinating bit of history. And eventually, I hope you'll all be able to read it when it finally gets assembled for publication. Today, though, I want to do the reverse. I want to start with a relatively contemporary development, that is with the Croft case itself, explain my thinking about that, and then dip briefly into the recent history of infringement decision-making to illustrate to you why I think Croft represents such a marked and potentially such a dangerous departure from the historically accepted mode of thinking about infringement analysis. And of course, as has already been suggested, the specific concern that I want to address is a concern that grows out of the language appearing, now I want to find the page citation on the never sufficiently to be studied page 1167 of volume 562 of the Federal Reporter, where the Ninth Circuit Court of Appeals picked up the language of total concept and feel and employed it as a kind of summative test for determining substantial similarity. I'm sure you're all familiar with the passage, but let me read it in any event, just in case some of you may not have read it, say within the last several hours. We have viewed representative samples of both the H.R. Puffenstuff show and the McDonald's Land commercials. It is clear to us that the defendant's works are substantially similar to plaintiffs. They have captured the, quote, total concept and feel, unquote, of the Puffenstuff show with a citation to the Roth greeting cards case. We would so conclude even if we were sitting as the triers of fact. There is no doubt that the findings of the jury in this case are not clearly erroneous. The summative test, the bottom line standard, if you will. The first sentence of the passage that I've read to you has appended to it a footnote, footnote 9. And I think that I ought to read footnote 9, or a bit of it as well, because footnote 9 illuminates, at least for me, what the court really has in mind when it speaks about total concept and feel. The footnote is as follows. Even a dissection of the two works reveals their similarities. The living island locale of Puffenstuff and McDonald Land are both imaginary worlds inhabited by anthropomorphic plants and animals and other fanciful creatures. The dominant topographical features of the locales are the same: trees, caves, a pond, a road, and a castle. Both works feature a forest with talking trees that have human faces and characteristics. The characters are also similar. Both lands are governed by mayors who have disproportionately large round heads dominated by wide mouths. They are assisted by Keystone Cops characters. Both lands feature strikingly similar crazy scientists and a multi-armed evil creature, etc. What the court is saying, at least to me, is we don't want to go into the details. We don't want to necessarily tell you what makes up this similarity of gestalt between the two works. But if we were to go into the details, these are the kinds of things. This is the kind of list on which we would be focusing. And that list is, to me, an interesting one, since so many of the things included on it would appear to be, by any definition, stock. I want to return in a little while to the question of how that approach to thinking about infringement analysis has fallen out in the decades since Croft. But before I do that, I want to suggest as emphatically as I can why I believe that Croft represents a true departure, a new taking off, so to speak, in the law of infringement, in the process by which judges have over time elaborated so-called tests of substantial similarity. There are lots of problems with the Croft case. There's the extrinsic-intrinsic distinction, for example, which I suspect no one understands very well, perhaps even including the judges of the court and the clerks who wrote the opinion for them. Certainly, if you look at the literature generated in the years immediately following Croft, including the article published by one of the clerks who was responsible for drafting the opinion, you find plenty of disagreement about the meaning of the extrinsic-intrinsic decision. I once took an informal poll at a Copyright Society meeting. I went around a table after dinner, admittedly, when people were none the better for alcohol, and asked if a cross-section of distinguished practitioners in the field who shall be nameless would each independently define for me the difference between an extrinsic and an intrinsic test, and satisfyingly, at least to me, each one of them provided a completely different definition from the next. So I won't pause, though, to talk about the pathology of Croft in all of its glory. I want to focus most specifically on total concept and feel. If you look at the opinion, it would seem that total concept and feel has got a pedigree. After all, it's cited to the Roth greeting cards case, which is, if not a favorite old standard of the field, at least a decision with 7 years priority, and one which during those 7 years had been widely cited and little criticized. So I think it's worthwhile to go back and ask, is total concept and feel in Croft the same as total concept and feel in Roth? My answer is no. You'll remember the Roth case and the issues it posed. That was a case involving infringement or allegations of infringement in the context of the wonderful world of greeting cards. The issue was essentially whether the defendant's cards, which combined the same trite and largely non-copyrightable elements as the plaintiffs, in essentially the same way, constituted infringement. And the court said, we think so. We think that even though most of the elements of the plaintiff's copyrighted cards are not in and of themselves protectable, the cute drawings, the silly slogans, the way those elements have been assembled is protectable. And that is what the defendant's cards have taken. In other words, in my view at least, the result in Croft is adequately explained by the most familiar principles of compilation copyright. The notion that even the work which consists entirely of unprotected bits of information can enjoy protection in its ordering and the sequencing which the author has imposed on those unprotected bits of material. Why the court in Roth, why the Ninth Circuit panel in Roth chose to invent, and as far as I can see it was in 1970 with Roth, an invention. Why the court in Roth chose to invent a new bit of terminology to describe the familiar principle that the ordering and sequencing of unprotected material enjoys copyright protection is one of the mysteries of the ages. Why they chose such a loaded, inflammatory, and potentially misleading form of words as total concept and feel, a form of words which on its face seems to deny so many truths and truisms of copyright doctrine, such as, for example, the familiar notion that ideas, concepts aren't protected under the law, is again mysterious to me. But the choice and the error in that choice were relatively innocent. The reasoning that phrase was chosen to encapsulate was of the most familiar kind. And, perhaps not unexpectedly, after Roth came silence, 5 years of silence, 5+ years of silence. until the total concept and feel language was picked up in a somewhat new context in the case of Ryer against Children's Television Workshop in the Second Circuit. Now, in the context of a more familiar sort of literary artistic copyright claim. I have a certain familial connection with the Ryer case, which I ought to acknowledge immediately. You may remember that the defendant in that case, Children's Television Workshop, had published in one of its periodicals a version, an illustrated version of a story entitled "My Mother is the Most Beautiful Woman in the World." Well, as it happens, the illustrator of that story was my grandfather, Tibor Gergely, a distinguished Hungarian artist who spent most of his later career as an illustrator of children's books in the United States. So when I first came to the Ryer case, I knew immediately that somehow this decision was destined to be meaningful to me, and indeed it is meaningful because it provides the link between Roth and Croft. The context in which the total concept and feel language is employed in Ryer is important to understand. Important, that is, if you are, as I want to do, developing an argument that Ryer, no more than Roth, provides a true precedent for the sort of use of total concept and feel reasoning that the Ninth Circuit eventually adopts in Croft. In Ryer, I want to pause a moment and find my copy of that decision so that I can read you the language. In Ryer, the court says this: "The question which remains is whether defendants in the instant case utilized the idea in Ryer's book or instead descended so far into the concrete as to invade her expression." Fair enough. We must first note that both stories intended for children are necessarily less complex than some other works submitted to pattern analysis. In other words, there's not much to work with if you just look at the plots. The plots are simplified, the plots are obviously related to traditional folk literature, not much material to analyze. Therefore, in addition to the essential sequence of events, plot, we might properly consider the total concept and feel of the works in question. In Ryer, the Second Circuit panel, in effect, uses the total concept and feel language of Roth to justify going beyond a mere comparison of plot and considering instead the similarity and dissimilarity of other non-plot elements that are contained in the two competing works. And ultimately, of course, it concludes that the two works are not similar in mood, details, or characterization. Having gone through a relatively detailed essay in analysis, contrasting the treatment of the mood, the story details, and the characterizations of the two stories. Once again, it seems to me the language is essentially surplusage. Once again, it seems to me the language of total concept and feel does little in effect to advance the reasoning of the court and would not really have been required in order to justify the analysis performed. There's nothing non-traditional about the analysis in Ryer. This is not the first and hardly the last case in which elements of creativity apart from plot have been thrown into the pot for consideration in connection with an analysis of substantial similarity. Why the court chose to invoke total concept and feel in order to justify going beyond plot is again to me a mystery. But what is crucial, in my view at least, is that the invocation of total concept and feel by the court in the Ryer case didn't prevent that court from performing a relatively rigorous analytic comparison of the two works, and in particular didn't prevent the court from noting which elements of the plaintiff's work ought to be discounted for purposes of comparison because they were in themselves unprotected. The court in Ryer, having invoked total concept and feel, goes on with a very conventional and, in my mind, very responsible analytic comparison of the two works, which emphasizes the distinction between what is protected and what is unprotected in the plaintiff's book. What Ryer did, however, was to give total concept and feel the appearance of both respectability and of new importance. Now it had been cited not just in a kind of marginal context like that of greeting cards litigation, but in a central and obviously important literary artistic infringement case. And it's not surprising to me, at least, that the Croft Court picked up on it the following year. The total concept and feel test originating in the Ninth Circuit with Roth had been laundered through the Second Circuit, so to speak, and returned in 1977 to the place of its origin, transformed in significance. Because, as the passage I read to you earlier from Croft indicates, what the Ninth Circuit in Croft has in mind for total concept and feel is something very different from what either of the two courts that had previously employed that language were up to. What the Ninth Circuit has in mind is a summative test, a test to be applied by comparison of the works in gross, a test which is sensitive to the full range of similarities between the works at issue in litigation, those that are in and of themselves protected and those which are unprotected as well. It's a totality test, so to speak, a test which is designed to make analysis unnecessary, or even, if it's sufficiently rigorously applied, to forbid analysis. Now, there are some other sources to which one might look for historical precedents to support the totality approach of Croft with its emphasis on non-analytic comparison. And the most obvious, of course, is the familiar anti-dissection principle, which we all learned about in law school when we studied Arnstein against Porter and its predecessor cases in the Second Circuit. The anti-dissection approach, of course, is closely related to the familiar principle, now perhaps honored more in the breach than in the observance, that expert testimony is not admissible on the question of substantial similarity. We all learned that when substantial similarity, as distinct from the issue of copying, was before the court, too refined, too subtle, too elaborate or professional an analytic approach was barred by the anti-dissection principle. And that can, with a little bit of massaging, be converted into something a bit like Croft's total concept and feel. I want to talk, therefore, a little bit about the pedigree of the anti-dissection principle to suggest to you that it doesn't, in fact, offer much, if any, historical support for the totality analysis of Croft. In order to do that, we've got to go back to the origins of the anti-dissection approach, which turn out to be in the teens and 20s in the Second Circuit, in a series of opinions by a much understudied and underpraised copyright judge, a judge whose opinions really formed the foundation on which the hands built their edifice, Judge Huff. And in two cases in particular, Frankel against Irwin and Dymo against Bolton, Judge Huff addressed, among many other important principles of copyright infringement analysis, the anti-dissection principle. Let me just rummage a bit and find for you a bit of language from Frankel and a bit of language from Dymo, which I think illustrate what Judge Huff had in mind when he talked about anti-dissection. First, in Frankel against Irwin, he begins the paragraph in which the anti-dissection principle is for the first time announced. This is a case of 1918, although mysteriously it wasn't reported until 1926. He begins the paragraph in which the anti-dissection principle is first announced with the familiar adage about not wanting to miss the forest for the trees. And then he continues, infringement of a work of imagination is determined by the result of comparative reading on the imagination of the reader, not by a dissection, there's the word, of sequences or incidents suitable for the study of a digest or a textbook, but are inherently unnatural for any man who has the kind of brains that make him able even to adapt a work of fiction. In effect, what Judge Huff is doing in that case is turning back the plaintiff's lawyer's attempt to base its case for infringement on an elaborate, professionally prepared parallel analysis of the two works. The theme is further developed in Dymo against Bolton. Here the metaphor is also further developed. Having talked about the two plays at issue, Huff sums up. This incomplete skeleton, that is of plot, the two plays have in common, but it is with real difficulty that the flesh and blood, the incidental yet essential adornment and trimming of the plays, can be cut away to show similarity between a few bones. There's dissection again, the essence of the metaphor. And what Huff is about here is suggesting that such dissection is inappropriate, that the plaintiff's efforts to make out a case beyond the high level and legally insignificant similarities of plot through stripping away the flesh and blood from the bones ought to be refused. In effect, I want to argue to you, historically, as first announced, the anti-dissection principle, as it came down in the Second Circuit through Judge Huff to the hands, was a narrow-purpose doctrine designed primarily to impose certain limits on the sort of evidence that could be received and given weight as part of a plaintiff's case for infringement. It's a long distance, to my mind, from that limited purpose which originally animated the introduction of the anti-dissection principle into American infringement law to the anti-analytic totality approach to infringement analysis announced in Croft. So I want to suggest Croft represents a genuinely, or represented 10 years ago, a genuinely new departure. And I want to suggest, too, that it's a dangerous departure. When I talk about this in my copyright class, I always try to illustrate the concerns with a hypothetical, and perhaps I'll give you a shortened version of that hypothetical for whatever it may be worth. Imagine a science fiction writer who has the notion, the idea, to write a science fiction version of Homer's Odyssey, and who sets about doing so, who creates a fictional world based closely on the structure of the Odyssey, but having certain new characteristics. Imagine, for example, that in substitute for Odysseus's ship, the hero of our author's new version is given a spaceship instead. Suppose that he is returning not from the Trojan War, but from an intergalactic battle. Suppose that along the way he meets not the Cyclops, but a one-eyed giant robot, and so on and so forth. You get the notion. I could elaborate further, but I'll spare you the details. And then suppose that this new science fiction Odyssey is introduced into the market and is a considerable commercial success. Many copies are bought, motion picture rights are sold, the whole thing attracts a good deal of attention. So much attention, indeed, that a second author sits down and sets about doing the same thing. Perhaps with Homer in front of him, and perhaps with nothing but the first author's work at his elbow. In this case, the familiar characters and plot structure of the Odyssey are again retained, but certain significant changes are made. Instead of the spaceship in the first author's version, the second author introduces a time machine. Instead of an intergalactic battle, the second author introduces a cosmic cataclysm of some sort, a natural disaster. Instead of a giant one-eyed robot, a giant one-eyed alien, and on down the line. This work is marketed, and predictably enough, an infringement action is brought by the author of book number 1 against the author of book number 2. Imagine how different the results of such an infringement action might be depending on the test the methodology for assessing substantial similarity that is adopted by the court. If an analytic approach, the approach which I want to suggest was largely current in the courts, at least where they articulated their methodology before 1977, the first step would be, of course, to discount those elements of the two works, and in particular those elements of the plaintiff's works, which were in and of themselves unprotected. That would include the major characters and, of course, the plot structure. Then a comparison could be essayed between what was left in order to determine whether, in the view of a lay audience member, the two works were sufficiently likely to generate the same response. What would have been left? Well, what would be left would be the specific embroidery on the traditional story which author one had devised. The substitution of the spaceship for the ocean-going vessel, the substitution of the intergalactic battle for the Trojan War, the substitution of the robot for the Cyclops, and so on and so forth. That would be left to compare with the specific improvisations and embroideries of author number two, the time machine, the cataclysm, and the giant alien. And I think on those grounds, although I never like to predict the outcome of litigation, even in hypothetical cases, I think on those grounds, using that methodology, it's fairly easy to say what the outcome would be. The outcome would be a finding of a very kind we're all familiar with from the books, that although the defendant may have caught a free ride on the general popularity of the idea of the plaintiff's work, there's no specific similarity on the basis of which a finding of copyright infringement can be premised. Now imagine the same case submitted to Croft-type total concept and feel analysis. Imagine the two works being analyzed in gross. Imagine all the elements of the two works being compared side by side, much in the way that the Croft Court in footnote 9 of its opinion said about cataloging the likenesses between the Puff and Stuff commercial, the Puff and Stuff show and the McDonald Land commercials. And imagine the outcome. If total concept and feel is taken seriously, if total concept and feel is taken as seriously as I think the Croft Court intended it to be taken, then a very different outcome is possible in our case. A very different outcome, since the two works will, if not submitted prior to comparison to some form of analysis, be likely to yield the same overall gestalt. Now, let me talk very briefly, since my time is coming to an end, about what's happened in the last 10 years. There are too many examples to cite today of instances in which the Croft total concept and feel language has been taken seriously. Too many examples to cite of cases in which courts have understood total concept and feel to mean what it said and have applied it as such. One case that I find interesting as an example of that, although it's by no means an important case, simply a typical one, symptomatic, you might say, is the 1982 District Court decision on the preliminary injunction in Universal City Studios against Film Ventures Incorporated, the Great White case involving shark movies. That's a case in which the methodology of the court corresponds exactly to what one would expect of a panel that was taking the Croft language for all it was worth. The opinion is studded with long lists of features in common between the two works, with no hint or suggestion that some of those features may be more significant than others for purposes of copyright comparison. We're told, for instance, that the major characters are the same. The shark in both films becomes a principal character in its own right. The salty skippers, both of whom have heavy English-type accents and are experienced shark hunters, are substantially similar. The politicians are similar. The local shark expert is similar. And then we're told about the plot. We're told that the opening scene in both films depicts teenagers playing on a beach. We're told that the scare technique of a false alarm is present in both films. In both works, the shark attacks a dinghy, and so on and so forth. It's a kind of list which you could prepare with respect to any two works of the same general genre. And that's what has been done in this case, and that's what justified the award of the preliminary injunction. As I say, there are many cases equally disturbing and equally typical with this one in the field of audiovisual infringement. It's in that field that I first began tracking the Croft phenomenon. But what I've noted in the last several years is that the Croft influence is now spreading beyond audiovisual works. It's spreading to cases involving literary and artistic copyright infringement generally, and it is spreading, of course, into cases involving issues of new technology. You're all familiar, I'm sure, with the respectful citation of Croft total concept and feel in the Whalen decision. In the earlier portions of that decision, in particular, if I can lay my hands on it, at page 1234, not only is Croft cited, but there is a particular parenthetical reference to similarities between McDonaldland characters and H.R. Puffenstuff characters can be established by total concept and feel of the two productions. It's my thesis, at least, that Whalen, which is a case that I think may go much, much too far in its definition of the scope of protection for computer programs, is animated by Croft-type thinking. That although Croft isn't specifically cited in the latter portions of the opinion dealing with the comparison of the 5 subroutines, the spirit of Croft walks through those paragraphs of Whalen as much as if it were cited on every line. Croft is everywhere, and Croft is likely to be with us more and more in time to come, even in the Second Circuit. Croft is gaining increasing acceptance as at least one of the available, if not the sole available, formulation of a test for substantial similarity. And that leads me to my last point or issue. So what? Things change. We had other tests, and as we all know, they were unsatisfactory. No test of substantial similarity has ever been much good, so why not try something new? Why not try Croft? So what if the net effect of Croft is to provide a little more or even a lot more protection to copyright owners in litigation? Why is that necessarily a bad thing? And I think the answer, to the extent that there is an answer to that question, implicates the most fundamental questions about the purposes of a copyright system. As you all know, one recurrent criticism of contemporary American copyright is that what was originally a specialized statute with a very narrow focus and applicability has been converted through legislation and through judicial interpretation over time into a kind of general federal misappropriation law. Croft is part of that process. But again, one could ask, why is that a bad thing? Maybe a general federal misappropriation law for intellectual property is exactly what we need in these troubled times. True, there does seem to be some tension between Croft and the traditional learning of copyright about the non-protectability of ideas. But again, who's to say that that is sacred? Some of my colleagues in the world of academia have written articles in recent years suggesting that the time has come to reconsider the shibboleth of idea protection and find a place in copyright, after all, for ideas. De facto, the Croft test has already done as much, but again, so what? Why should one be concerned? Why should one, as I do, deplore that development? The reason, I think, has to do with the vision, the original vision of the purposes of copyright as it has come down to us over time. If all this debate were about was assigning benefits at the margin to users or producers of intellectual property, as the case may be, if all we were talking about, in effect, was the law as it affects pricing, I wouldn't be terribly concerned about Croft. Indeed, I wouldn't be terribly concerned about copyright, and I probably wouldn't be involved in the field. But it's not the only concern. Indeed, it's not even or shouldn't be even our major concern. Our major concern ought obviously to be the question of whether or not we're running a system which creates the social and economic conditions under which certain kinds of socially valuable creativity can flourish. And it's here that my concern about Croft is rooted. It's very presumptuous of somebody who has no particular background in the field like myself to talk about the nature of creativity, and I'm not going to talk about it for long because I feel uncomfortable in doing so. But I want to point out some coincidences which have occurred to me and which may also perhaps have occurred to you. If you look at the history of creativity, broadly defined, if you look at the historical moments at which particular kinds of creativity have flourished most intensely, if you look at Renaissance Florence or the London theater of the late 16th and early 17th century, or Hollywood between 1895 and 1925, or the American software industry in the late 60s and 70s, you find, along with many differences, some shared characteristics. And one of those shared characteristics is that there's a high level of borrowing going on in each one of those cultures. Renaissance painters, Elizabethan dramatists, Hollywood filmmakers, and modern American programmers, at those moments of intense cultural flourishing, stole from one another right and left. Not without limitation, not without sanction, but to a remarkable degree, the premises of those cultures at those moments of flourishing were shared. And there was relatively little complaint. Indeed, it was typical in those periods for one whose work had been used to feel flattered rather than affronted by the fact of that borrowing. I'm not sure that it's a good thing to change our legal rules, at least without due consideration, in a way that is going to shut down or prevent the future development of these pockets of intense creative flourishing characterized by extensive borrowing. I think we need to think a lot about the relationship between borrowing and creativity before we allow our courts to accomplish de facto a redefinition of the scope of copyright protection which may have important implications for the future of the creative establishments in this country. I'm not going to suggest to you that Croft and what Croft stands for is necessarily wrong, although I believe fairly deeply that it is. That's a personal belief and not one that I think is going to be easy to persuade anyone to follow. My point is a more modest one, that the kind of change in law which has been accomplished over the last decade and which is ongoing today as a result of the introduction of the Croft Total Concept and Field Standard is the sort of change which really deserves wider discussion and deliberation before it is finally written into our laws. Whether that means that it's an appropriate topic for legislative discussion, whether it means that it's an appropriate topic for further activities in this office, whether it means, as I'm sure it does, that there ought to be wider academic debate and discussion of the proper standard to be applied in the law of infringement, is for the actors in each of those fields themselves to decide. But I am deeply, deeply concerned that we are, as members of this copyright community, allowing a development to take place, understanding it only partially and resisting it not at all, which when we look around, say 10 years from today, on the 20th anniversary of Croft against McDonald's, may have permanently changed the landscape of our copyright laws in ways which we or some of us may then, when it's too late to do anything about it, find we deeply regret. So it strikes me that the next 10 years are going to be crucial ones, and that we all need to think about what our roles may be in what I hope will be a much more vigorous and active debate concerning the appropriate standard for assessing copyright infringement. Sure, absolutely.
Anyone have any questions? Perfectly clear.
Please.
It sounds to me like one of the things you may be suggesting is that the test of substantial similarity was replaced by perhaps a test of is something offensively similar, and then questions of more equity law, unjust enrichment, economics, good guys, bad guys, and so forth, have come into play in a very major way in these cases. It seems to be a common thread around.
I think that's a very fair characterization, and I think that fits in with this somewhat unfair, but not completely inaccurate characterization of recent developments in copyright law as tending to convert the statute into a general misappropriation law. Because after all, that's all that matters when you come right down to it in a straight misappropriation analysis. Good guys and bad guys are everything. Now, those factors have never been absent in copyright infringement analysis. Indeed, they've always been important. We've always recognized their importance, even if we had to read between the lines to see it. But in the past, pre-Croft, I would argue, the methodological approach to infringement analysis, which was essentially analytical in character, kept those factors not at bay, but confined to a particular place in the analysis. They were significant at the margin. What may be happening with this change is that they are being wheeled in and placed center stage. And again, were there nothing involved except the distribution of benefits at the margin between users and producers, I would say, so what? Probably in general that's appropriate. Because I am concerned that there is something else involved, and that we may find that we are selling off the most fundamental values of our copyright system in order to confer short-term benefits on deserving producers, I think we need to keep an eye on this development. I think it's very, very, very well put.
You testified on that.
Haven't made a request, you think I should?
We can vote.
Sounds good to me. Be delighted. Would be very interested in doing so. Absolutely. Especially if it means I could cut class. Always looking for reasons to cut class. You have, by the way, heard in the last half hour most of my copyright course. I spend, in the ordinary year, I spend 14 weeks working up to what you've just had without any of the preliminary fuss and bother. So you should feel very privileged.
Maybe we should ask Elliot whether or not it brings back
Or perhaps we shouldn't. Yeah?
Well, I was curious about the computer program case that recently, and I wondered if the court's approach to dealing with the concept of total field is a way of avoiding relying on expert witnesses so much to determine the actual similarity.
Well,
Since computer programs really don't look a lot alike, like an audio-visual one may look like another.
let me answer in two parts. I generally agree with you in this sense, that I think that one of the reasons the total concept and field has caught on, one of the reasons it's been so big in the last decade, is precisely because in all kinds of cases, not just computer cases, but also difficult infringement cases of all sorts, it gives courts a convenient way of not doing hard work. Courts love easy tests. And this one is easy, at least in the sense that you don't have to go through a lot of preliminary workup to apply it. I'm not so sure about the computer cases, on which I'm no great expert. Whalen, it seems, has it both ways. Whalen has total concept and field and experts. And indeed, it seems the question of total concept and field is left to the experts. So the two aren't necessarily inconsistent. Perhaps they ought to be, but at least as far as Wayland is concerned, they go together, and by the time you're through, the judicial role has been more or less completely abdicated. It's been abdicated once through the reliance on total concept and feel, and again through the dependence on experts. Now that may be inherent in the difficulties of the second generation of computer cases. It may well be that some mode or means of getting the expert testimony in is going to have to be found. But I think if it's going to come in, I would be comfortable or more comfortable having it come in on the issue of substantial similarity under some rubric other than total concept and feel, which gives the decision maker already latitude to reach unexplained conclusions that makes me uneasy. So I don't, perhaps the two things ought to be mutually exclusive, but I think in practice they're not. They go together. Yeah.
Where would you put the Nichols versus social pictures in the analysis?
Well, I think that Nichols is a very, very good example of a traditional analytic approach, an approach which concentrates on discriminating between unprotected and protected elements before applying whatever summative test of substantial similarity is applied. I think that's what the pattern formulation is all about. Whether one finds the pattern test easy or hard to apply, whether one finds it a useful test or not, and I frankly have lots of difficulties with it in practice, it is an attempt, an effort to get at the difficulty of how it is one accounts for the presence in protected works of unprotected material before moving to whatever summative test of substantial similarity is applied. And it's that, it seems to me, that Croft, in effect, gives up on.
They're also eager to get back to work.
Well, I've clearly just stunned you all with these perceptions. Thank you very, very much.
Excellent presentation. Thank Jody for showing up.
It was a real great pleasure to be here. Thank you.
I'm going to take the wire off.
Oh, yes.